Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Well, we are in early 2023, and the pre-filing of some proposed bills are beginning to hit the state legislature website, and we are beginning to spot some new gun control legislation that's coming through. Nothing has come as a shock yet. We're just kind of waiting for more bills to drop. However, today, January 5th, 2023, we had not one, not two, but three new bills drop in the House. They have numbers assigned to them, and we're going to get you up to speed on that. Not anything that we didn't expect, but now that we can actually see the language and see what they're trying to do, yes, it is as appalling as we thought it was. So today, let's spend a few minutes and talk about all the new ways the Washington State Legislature will try to disarm its citizens in 2023. Okay, three bills that I want to get you all up to speed on. They are all House bills. Two of them are really similar. I have not really had enough time to go through with a fine-tooth comb and figure out what the differences are. And then the third bill is quite different, deals with a different subject matter. The two bills that I'm going to get you up to speed on first is House Bill 1143 and House Bill 1144, both sponsored by Representative Berry at the bequest, of course, of the governor and the attorney general. What 1144, 1143 does is two things, and I want you to be very careful of this, and we'll get into the more specific language about it in a little bit. But two things. Number one, it amends RCW 9.41.092. That is our statutory waiting periods. As we know, depending on the type of firearm that you are buying in Washington State, if it's a rifle or a shotgun, as soon as the background check clears, it's yours to take. When it comes to handguns, it is either as soon as the background check comes in or 10 days, whichever occurs sooner. And when it comes to semi-automatic rifles, it's 10 days no matter what. So whether the background check comes back right away or not, if you have a semi-automatic rifle, you're waiting 10 days under RCW 9.41.092. Both of these bills, if enacted into law, would change all waiting periods, no matter what the platform of firearm you're trying to buy, to 10 days. So we would have a mandatory 10-day waiting period for every type of gun we buy, regardless of when our background check actually comes in. But the big piece of legislation that is in both of these bills is this is the first announcement of our pre-purchasing licensing requirement, very similar to the atrocious piece of legislation currently being litigated down in Oregon, that of course being Oregon Ballot Measure 114. This is almost as bad, not quite as bad because of, I think they took a look at some of the things that Oregon had completely loused up and have tightened the law up a little bit. Now, does this make this law constitutional? No, because the last time I checked, we don't need a hall pass from our governor before we go exercise a constitutional right. But we do begin to see what kind of training is going to be required if this became legislation. We do begin to see how much this is going to cost us and how prohibitive it is going to be on us. So let's dive into that for a minute. Okay, so again, this is a bill and it's a long way from being legislation, but if this were to become law, in order to be able to purchase a firearm in the state of Washington, you would need to have a license to possess. Let me say that again. In order to purchase a firearm, exercise a constitutional right, you will first need to get government's privilege from them in order to do so. And you begin to see what the problems are. Now, what would that training require? Well, that is spelled out in both of these bills in Section 2 in both. And according to this proposed legislation, the training here required in order to get your license so that you can then just go buy a firearm would include the following. 1, basic firearm safety rules. 2, firearms and children, including secure gun storage and talking to children about gun safety. 3, firearms and suicide prevention. 4, secure gun storage to prevent unauthorized access and use. 5, safe handling of firearms. 6, state and federal firearm laws, including prohibited firearm transfers and locations where firearms are prohibited. Now, if you take a look, those first 6 components of that curriculum are everything that was in the 1639 safety class, a class that we know has saved thousands of lives. But in addition to the curriculum that carries over from Initiative 1639, this bill also proposes additional curriculum in the safety class, including 7, state laws pertaining to the use of deadly force for self-defense. 8, techniques for avoiding a criminal attack, and how to manage a violent confrontation, including conflict resolution. And 9, live fire shooting exercises on a firing range that include a demonstration by the applicant of the safe handling of and shooting proficiency with firearms. So that includes all the curriculum, which, as you can see, has, listen, I have no problem with the issues about self-defense laws and all that. I think everyone should bone up on that. Now, conflict resolution, I don't know who the hell is going to be teaching that. And then when it comes to the live fire drills and what the state is going to deem to be proficient, we have no idea what any of that means at this point. As near as I could tell, the difference between House Bill 1144 and 1143, which is significantly thicker, is 1143 is much more thorough about including all of the other statutes where if a person were to lose their right to possess a firearm for some type of criminal conviction or other activity, then it also includes their loss of their firearm purchase license. Once again, those are House Bills 1143 and 1144. Now, the next one is House Bill 1130. And this is one that I think a lot of you lawful and responsible gun owners are just going to kind of shrug off, because this just doesn't deal with me. It deals only with the FFL industry. But what I'm telling you all, and you all need to pay very careful attention to this piece of legislation, is this piece of legislation is designed to do one thing and one thing only, and that is to run as many FFLs out of business as humanly possible. Okay, so let's talk about what House Bill 1130 does. House Bill 1130, and we've talked about it already in this video right here, but what it essentially does is it would redefine public nuisance and expand its definition greatly so that it would encapsulate almost any activity that an FFL may engage in. Now, I think we can all agree that FFLs who knowingly allow straw purchases, knowingly sell illegal firearms, knowingly sell to unlawful people, those people all constitute a significant safety risk. However, I am not aware of any FFL in the state of Washington who engages in such practice, and certainly if we take a look at the history of FFLs nationwide, we know that that is an incredibly small minority of businesses that engage in this practice. Now, remember that this piece of legislation was written with the idea that the mere presence and selling of firearms constitutes community danger. But in addition to expanding all of this activity that an FFL may engage in, understand that simple clerical errors can now constitute a public nuisance. And this is the other thing. This statute specifically says, hey, if a third person intervenes and acts illegally with an otherwise legal product, that doesn't necessarily make the FFL immune from this statute. In fact, the bill, if enacted into law, would specifically read, a firearm industry member's conduct in violation of any provisions of this section constitutes a proximate cause of the public nuisance if the harm is reasonably foreseeable effect of the conduct, notwithstanding any intervening actions, including but not limited to criminal actions by third parties. And the legislation would also dictate what types of products an FFL can sell, because certain products, if they sell them, would in itself be deemed a public nuisance. This bill, if enacted into law, would specifically make it a public nuisance for any FFL to sell an accessory or device that is designed or adapted to be inserted into, affixed onto, or used in conjunction with a firearm if the device is marketed or sold to the public, and that it is designed, intended, or able to be used to increase a firearm's rate of fire, concealability, magazine capacity, or destructive capacity, or to increase the firearm's stability and handling when the firearm is repeatedly fired. Now, we're talking about items that increase a firearm's concealability, like what? An inside the waistband holster. We're talking about items that make the shooter more stable in shooting, thus more proficient and safer in the shooting. So we're talking about vertical foregrips and things such as that. We're talking about increasing the destructive capacity. Does that include hollow point ammunition? We're even talking about increasing magazine capacity. But what if an individual increased their 6-round magazine to a 10-round magazine, still being compliant with state law? Does that really constitute a public nuisance? Well, under the language of this bill, yes, it does. But if you think that's all terrible, wait until you see the blank check that this bill gives to the Attorney General to absolutely run roughshod over any FFL that they put in the crosshairs. Because this bill specifically states, whenever it appears to the Attorney General that a firearm industry member has engaged in or is engaging in conduct in violation of this section, The Attorney General may commence an action to seek and obtain any remedies available for violations of this chapter, and may also seek and obtain punitive damages up to an amount not to exceed 3 times the actual damages sustained by the state, reasonable attorney's fees, and cost of the action. And so what House Bill 1130 should be called is the Put the FFL Out of Business Bill of 2023. So once again, the 3 bills that you can do, we'll put a link for all of the pre-filing bills, and I encourage all of you to go there every day and check them out. Certainly as more bills are being filed, we're going to get you up to speed. 1143. Okay, 1143 changes our waiting periods and also has all of the pre-purchasing licensing requirements in there. 1144, it's almost identical to 1143, but shorter and easier to read. And then 1130, a significant shift in FFL liability. The legislative session, as you recall, gets underway on January 9th next week. We will keep you guys posted, just like we did all last year, on any new bill that drops and where it may be going. In the meantime, if any of you have any questions about this or anything else of what's left of your Second Amendment rights, you guys know how to get a hold of us. You can always contact us at WashingtonGunLaw.com, or you can call us directly at 425-765-0487. In the meantime, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.